Hello, everybody. I'm sorry for this delay, and I am confident that everybody is able to follow our panel, our roundtable, plenary roundtable. We are the first one on future of international investment regulation. I am Giorgio Sacerdoti of Bocconi. If you have followed the opening interview to Professor Monti, you have seen me already. And we have a very distinguished panel, Yas Banifatemi, who is a known arbitrator, counsel. She was many years with Sherman and Sterling and recently opened with Emmanuel, a specialized law firm in Paris on investment arbitration. And we mourn really Emmanuel Gaillard, a great friend, who suddenly passed away prematurely a few weeks ago, just after he had launched his new endeavor. Gabrielle Kaufmann-Kohler, she doesn't need a presentation. She's a key figure in investment arbitration, formerly a professor at the Graduate Institute in Geneva and the founder of the Master in International Dispute Settlement, which is forming many young lawyers, not only in arbitration, but also in international disputes. Nicolás Perrone, I'm following in alphabetical index. He joins us from Universidad Andrés Bello in Santiago de Chile, and he has written recently on investment regulation. He's also a critical voice, and we look forward to his intervention. Hélène Ruiz Fabri, professor at Paris 2, and since many years, the founder and the director of the Max Planck Institute on International Procedural Law in Luxembourg. And finally, James Zhan, serious director at UNCTAD. He is key in the World Investment Report, which he follows year after year and gives so much reflection and information on the investment regime, not just legally and also economically. And his unit is also very active in proposing new models of investment treaties and agreements in this field. So I start with a short premise on the future in international investment regulation. As all those who follow us surely know, there is a lot of criticism on the current system, especially not only on the substantive, the standards of protection of investors, but also on ISDS, on the rules on dispute settlement. And these will be addressed by my colleagues, so I won't dwell much in this. But on the other hand, the system seems to be performing well. There are more treaties being made, also chapters on investment in regional treaties and in FTAs. Ecuador, a critical of the system, has rejoined the ICSID recently. And here I have the numbers of the ICSID cases. You see how they're going up and staying up. Of course, this system is not just to foster disputes, but also to give confidence and promote investment. But in any case, there have been more than 800 cases since ICSID beginnings, which really started to be active in 96, 97. And we can compare this with the 600 cases that have been filed in the dispute settlement of the WTO since the beginning, which was also 95, 96. So the judicialization or adjudication of both pillars of international economic law seem to deliver service to the users, to the states and to the investors. With this background, I ask first to Yas to comment. We'll have a round of 2-3 minutes, then we have another question and so on. Please, Yas.
Thank you, Giorgio. Good morning, everyone. I will say a few words about this, the health of the system and how we measure that. And I think that as any other system, and if we are considered treaty investment protection as a system, we can measure it in its ability to function properly. And you've mentioned the figures and the fact that it does function properly, but also its ability to address the shortcomings and the inefficiencies that will come along the way by definition, because if it's a system, it will have shortcomings. So the ability of that system to address and fix through self-regulation, I think that that is the measure of a healthy system. And if we look at investor-state dispute, we've seen a number of criticism. Early 2000s, as soon as we had the Argentinian cases, there was a number of criticisms about the malfunctioning due to lack of harmony, lack of transparency. And later on, since about 2010, for a bit more than 10 years ago, we've started hearing about backlash. And that has really been the theme that we've heard a lot. I want to pay tribute to late Professor Caron in his analysis of the backlash, his article on dissecting backlash. And he did say that in his view, to what I adhere, the backlash against investor-state arbitration materializes and it reflects broader concerns about globalization. And I think that that is the context and the general context against which we should also look at the system. So if we look at how it has self-regulated, I want to really focus on two ways that it has done so. The first is the case law, simply the way that arbitrators have approached the field, have looked at the difficulties and the challenges and have addressed them. You can see that the lack of harmony is not that that much of a problem. Professor Gaillard wrote that, a bird's eye view, if you look at it from a bird's eye view, you see that there's much more consistency which is exceptional in a decentralized system than what you would expect. You have case law on illegality, the major issues: illegality, corruption, abuse of process, notion of investor, notion of investment, the case law in relation to bifurcation, and how the arbitrators themselves have been regulating and addressing the issues as they come. The other point I want to make on this is, if you look at the statistics, you see that, again, the arbitral case law is relatively balanced. You have only in 28% of the cases where investors secure damages awards. You have 37% of the cases, these are UNCTAD figures, 37.2% of the 700 publicly known cases where the states prevail. So the system is balanced, and arbitrators do look in a balanced way, if you look at the overall picture, in the interests of both parties. And if you look at another way that the system self-regulates, is simply treaty making. And you have seen, and the EU model has helped in that regard, you have seen new versions of treaties where you have counterclaims, additional waiver clauses to avoid prior proceedings. You have a definition of investor for corporate investors where you now have a lot more focus on economic business, substantial economic business activity, in the territory of incorporation. So the system does self-regulate through treaty making and through the work of the arbitrators, and I think that's they're central in the system, and we should not forget that. So as a final remark on this, I think that looking at the reform, it's not an overhaul for me. It's simply improvement, looking from a bottom-up perspective. What does not work? Try to fix it and improve the system as we go, and not to throw away the baby with the bathwater, because this, we should not forget that where we started was diplomatic protection and the Calvo Clause, and a century of evolution, I think, is something that we should keep as our heritage in relation to rule of law. And again, the increase of cases and the increase of treaties in the field show that there's confidence in this system, and that states continue to adhere to these treaties because simply it allows them also to attract investment. So I'll stop there. I'm sure that we'll have much more to discuss. Thank you.
Thank you very much. Yes, I give the floor to Gabrielle, please.
I would say the picture is mixed. There are signs of health and there's signs of illness. And I can go into more detail in a minute, but I think that requires some reform, and the reform should be both on the procedural side and in respect of the substantive standards. On the procedural side, it seems to me that the substance of some of the criticism and the perception in the wider public of the system, and also among a number of states, is not as it should be. And maybe the main criticism is really legitimacy. And that goes in the narrow sense. It goes to the person of the arbitrators, the way they are appointed, that are not in line anymore with democratic values. And this is because we have private individuals deciding cases about international responsibility of states, and they are just party appointed, and somehow there's a lack of accountability. Obviously, legitimacy derives in international law from state consent, and states have consented to the system, although they're in part retreating now, but they have consented. However, at the same time, there is also a legitimacy that is not in legal terms, but more in sociological, political terms that needs to be taken into account, and that is now being challenged. So there's a procedural setup that needs to be revisited. How this can be done, we can discuss later that there's different ways of looking at it. Anyone who attended the UNCTAD, the 2 weeks of UNCTAD sessions about 3 years ago, about whether there were criticisms, or they didn't call it criticisms, they call it concerns about investor-state dispute settlement in its present stage, hearing all the states making raising criticisms, would not doubt that something needs to be done. Obviously, there's also possible reforms on the substantive side, and we do see states making changes in investment treaties. I leave this for others who may be better informed than I am to discuss this. I understand in particular that James would cover this point more. So in the interest of time, I stop here.
Thank you. We'll have more to say. So Nicolás, this is your turn, please.
Thank you, Giorgio, and thanks, SIEL, for the invitation. I'm very happy to be here. So I'll take your question from a slightly different angle. So, I want to discuss whether the investment regime remains relevant and influential. So I mean, the question is whether this regime continues to shape foreign investment relations. I mean, not only between state and investors, but also with other actors, such as local communities. And I think the answer is yes. I mean, there are 3 reasons, I would say. The first one is that there are still more than 2,500 investment agreements in force, according to UNCTAD. This includes bilateral, plurilateral chapters in free trade agreements, as you mentioned, Giorgio. It's true that some countries have terminated their treaties or denounced the Exit Convention, but then others have also rejoined, I mean, Ecuador recently. So from this side, the system seems to still be, structurally relevant. I think there is a second point, is that the system remains very relevant on a case-by-case level. There are a large number of investment disputes that are being resolved through ISDS, and many others have been resolved through commercial arbitration. The problem is that because of confidentiality, we don't know about them, but that number is quite important too. So ISDS remains the main dominant paradigm when it comes to investment dispute settlement. And if there is a competitor, that competitor is commercial arbitration. And I think this reflects the view of most states as well. I mean, in the case of Latin America, the region where I'm from, most governments approve of ISDS. I mean, this includes Argentina, Colombia, Chile, Peru, probably Ecuador now too. So, I mean, most governments in Latin America continue to favor ISDS. But I want to focus on the third reason why I think the investment treaty regime remains influential. And this is a systemic level. I think most governments, official practitioners, and most academics continue to think about foreign investment relations through the lens of the investment treaty regime, through the lens of ISDS, through the lens of investment treaties. So I'm not talking only about the ISDS cases here, but more broadly speaking. So I recently pointed that what emerges from ISDS, from the standards, it's a sort of legal imagination, a legal culture. This can be traced back to the treaties, in the 1950s and 1960s. And that imagination has occupied the space of investment, of international investment, defining how foreign investors and states relate to each other, how we represent, how we conceive state measures, not only the measures that affect investors, but also the measures that favor them. So there is a close relationship here between what I call regulatory givings and regulatory takings. So my point here is that we think about international investment through ISDS and foreign investment. This shows that they are very relevant. So this legal imagination, this legal culture that results from both the treaties and ISDS have occupied the space of international investment. So it's difficult to think outside of this box. And even the critique, I think this is very important too. I mean, the critique is shaped by the investment treaty regime too. It's a reaction to investment treaties, a reaction to ISDS, as we just heard from Yas and Gabrielle. So overall, I would say that the investment treaty regime remains very relevant. ISDS is the preferred method to resolve the dispute, and the regime is the main point of reference for any discussion on investment law and policy. Now, the question is, what are the implications for this? And I think we're going to touch on this question later. So I'll leave it here for now. Thank you.
Thank you, Nicolás. Now is the time for Hélène, who is Fabri, please.
Thank you, Giorgio, and thanks to you and SIEL for having invited me to contribute to this panel. My answer, looking at the health of the system, I couldn't find any straightforward answer because it depends the point of view you adopt here, and this is probably what my answer will look very mixed. In fact, if you think, it depends whether you think, for example, that law is indeterminate or not. If you think that there is an fundamental indeterminacy of law, as people like Koskiniemi do, the problem is not the way the agreements are written and the fact that maybe the standards are very flexible and the case law is not predictable, and so this kind of criticism you've heard. And there can be two explanations in this case. One is that there is a structural bias in the treaties themselves, and they are oriented with an inherent pro-investor logic, and this logic imprints the whole field, and therefore this is, the criticism are addressed to this bias. Another explanations, if you believe in indeterminacy of law and which help assess the health of the system or criticize it, is a sociological one, which Gabrielle already tackled briefly. But the criticism is more or less that this has to do with the people who circulate in the system. It has to do with the quasi-incestuous nature of the system, and therefore the answer will be more procedural there. But if you don't believe in the indeterminacy of the law, then again, you can have two approaches to the health of the system. And on the one hand, you can focus on the gaps and the insufficient structuration of the treaties themselves. The treaties are not sufficiently clear and precise, and then you need to revise the treaties. Or it could be also a problem of values. This should be a second dimension. And you would need to have in the treaties more clauses that take into account non-trade or non-economic, so-called non-economic values to allow the system to be healthy in the sense of taking into account very broad values. And there is another dimension you can add to these perspectives, which is something, for example, that Paulsen wrote in a Chatham House paper. The fact that you can reflect on how to make treaties in the future and how to change them. This is the reference that he has made to new treaties and the fact that the system is self-regulating. That's true indeed, but at the same time, Paulsen underlines that there are still 2,500 treaties or so, which are old treaties according to the old models, and these treaties are still in place. And therefore, one issue is, can you expect that the system becomes healthy while having this heavy luggage of old treaties carrying this old approach? So there might be solutions, but I just wanted to put on the table these various arguments and perspectives that you can take to assess the health of the system. So my conclusion can look rather agnostic, but at the same time, I think it's important to keep in mind one aspect that Gabrielle also underlines, the importance of public perception of this, and including of probably less informed than we can be people on the system. Thank you.
Thank you, Ben. We have now James Zhan, who I think will add us perspective of the substantive rules and the role in future investment regulation. This is a field in which his unit and generally UNCTAD has been quite active. Please, James.
Thank you, Giorgio, and thank you to SIEL for inviting me to this very interesting conference, particularly this panel. My first point, very briefly, the health of the system. I would say the health of the system is in the eyes of the beholder, whether it's healthy or not healthy. There has been heated debate. We initiated reform back in 2010, and that was in light of the global financial crisis, and all sorts of issues came up, procedure and substantive. It's still heated debated. Now, I wish to focus, as Giorgio asked me to do, is the future direction. I would highlight the drivers and the directions. Drivers, I would say there are two major drivers. One is the deglobalization, the other is the sustainability imperatives. The deglobalization process becomes a factor now, and that will lead to kind of a realignment of the governance, international economic policies, and then there's also kind of inward-looking industrial driven. And these are the facts we have to see. According to our statistics in the database, that over 100 countries have some sort of formal industrial policies, and a lot of them are really inward-looking, made in my own country, and this is the driving forces for regionalization, reshoring, nearshoring, particularly in manufacturing. So that's one driving forces that will impact on the future investment policy making at the national and the international levels. Now, the sustainability imperative, as you all know, the SDGs is a big movement, and then there's a kind of a growing pressure on corporate accountabilities, illicit payment, tax avoidance, and other kind of ESG movement. They are all coming in that will impact on the formulation of future investment laws and regulations at national level and IAs at international level. So the drivers will continue to make, I would say, will make the pendulum to swing towards the middle range and it has reached almost a kind of inflection point, and there could be a kind of further moving towards from the liberalization to regulation. That's what I can see. Now, for directions, I would say in the area of IAs, the first, I would say that mega regional treaties will take the lead, and that may that driving forces has already started. That's why we see the kind of drastic reduction of new bilateral investment treaties concluded, but then more participation in the regional ones. That's the mega regional ones, not only in terms of numbers of participation of countries, but also kind of more influenced in the future by geopolitical factors. That is coming, and that's getting bigger. And then also in terms of substance, I would say there will be a kind of drive for mainstreaming of sustainable development. So you will see in the new treaties more and more provisions related to labor, environmental competition. All these issues are getting in big, and that's the kind of expansion of the investment law instead of cross-referencing of with other laws and regulations. The third, I would say the direction is the weakening of the traditional hardcore principles, the principles of non-discrimination, for example, the NTMFN and FET. These, we see more and more cover-outs, and we see more and more kind of nuance into it, or even abandoning some of the provisions, for example, FET, in the new treaties. Now, the fourth, the direction I see is more related to the old generation of IAs, the BIDs. You may note that not only the reform is ongoing, there are several kind of approaches to dealing with the old generation of investment treaties. One is through the consolidation, and that partly because of the mega regional treaties, like EU is trying to abrogate the old generation of treaties among the membership. But there are others replacing the bilateral investment relationship governed by the bilateral treaties with the kind of a regional, sub-regional, and cross-regional type of treaties. And the second, when you see the kind of modernizing, updating, this is the track through the kind of reformulating the models for model treaties at the country level for renegotiating of treaties, and some countries start a kind of joint interpretation of some provisions of the old treaties. Not to mention there's also the approach of some countries to just simply walk away from the old bilateral treaties, or they terminate unilaterally or with mutual consent. So so that is going on despite the fact there are 2,500 investment treaties still in force. But you may wish to note one phenomena. If you look at ISDS cases, it reached over 1,000 last year. Not 1,000 cases, but the new cases are really triggered by the old generation of treaties. If you look at the 400 to 500 new generation of investment treaties concluded since 2012, you hardly see any ISDS cases. As time goes, what will be the scenario for ISDS? Not to mention of the reform of ISDS itself. It's a kind of fixing of procedure aspect, but the other aspect, substantive aspect, the new generation of treaties, particularly led by the mega regionals, driven by the sustainability imperative, that erode the hardcore principles in the past, and more of getting in ESGs into the investment lawmaking. that's the direction it's going. I'm not saying that I'm not concerned about the erosion of the hardcore principles on non-discrimination, but this is the modern thinking of the treaty making now, and it's happening. It is slow, but it will reach the kind of a stage that we see the inflection point for the investment treaties, particularly that relate to ISDS. And regarding ISDS, there are different approaches now. If you look at the new treaties concluded, the ISDS provisions are really not as strict as in the past, or there are different approaches like investment court system type of thing that the EU is approaching. I think the pressure is mounting again. Another factor I would like to mention is this: the traditional drivers for the market access, investment market access, is diminishing because the investment home countries, the investors' home countries, have less incentive in pushing for market access. Therefore, there will be a weakening force for pushing for liberalization provisions, market access provisions in the new investment treaties, because the advanced countries more concerned about preserving jobs at homes. So they are, instead of encouraging all that fighting for the way of the multinationals in foreign markets, they try to do the opposite, reshoring. This is particularly the case for manufacturing sectors. Of course, in services, we'll see the direction of further fragmentation, outsourcing of white collars jobs, but that's only one aspect, and then there's a limit to that. So this is driving forces for market access in the future and stronger protection. That driving forces is weakening. That's another observation I just wish to point out, and that will in fact impact on the future investment policy making. Now, in terms of the trends by group of countries, this dichotomy continues, but moving into the middle, I'm talking about the two dichotomies. One is liberalization versus regulation. And we see in the past, in the 90s, or the first decade of the century, that investment promotion, facilitation, more incentives has been the main driving forces for the investment treaty making and for the investment policy making at the national level, and that was over 90%. And what is today now? The ratio of restrictive measures vis-a-vis the liberalization, facilitation, promotion measures is now 41 to 59. It means that from barely 5% of restrictive measures and new measures put in place 2 decades ago to now is close to half restrictive in nature. In addition to that, we also need to look at the nature of this restrictive measures, mostly put by the advanced countries, which account for over 70 to 80% of the global FDI flows. You have less countries, less number of measures restrictive, but they impact more of investment flows because they are large recipients. I'm talking about the tightening of the screening and monitoring. And this, so interestingly, developed countries are moving. Should I stop here, Giorgio? I've talked too much about.
Okay, we have further rows. I think your statement, Zhan, if I may say, is something that's quite interesting, because on one hand you say the push from, let's say, a home country to gain market access for the companies investing abroad is reducing. You mentioned protecting labor, reshoring. While that was the policy of Trump, I think that was reflected in the new NAFTA, let's call it, vis-à-vis the old NAFTA. But on the other hand, which have the European Union negotiating a comprehensive agreement on investment with China, where the push of the European Union was very much to ensure more opening and fair treatment or national treatment to European investments in China, which are quite important. Another reflection I have from the general debate is there is more domestic regulation affecting foreign investment because there is more emphasis on the right to regulate and this concern on screening. This would increase, on one hand, the need of foreign investors to be protected by treaties because there is less liberalization and more possible interference. I mean, we had the notice the other day that Keystone Pipeline, the Canadian pipeline, which was projected by the United States, shoal gas to 1,000 United States, is being stopped by the Biden administration, and they have announced a possible action, ISDS, under the old NAFTA, the grandfathering clause, for $15 billion in damage. So it's quite lively. But,
Giorgio, if I may, I'm just saying that this is important. I'm saying that the pendulum is swinging towards the middle and maybe towards the other side, other directions. This is all compared with the past. All these erosion, all these kind of shifting is there. It doesn't mean that overnight there's no liberalization. Overnight there's no effort of concluding new investment treaties. But
yes,
compared with the past, it is totally different scenario, and the future direction is quite.
There has been, you know better than I, diminishing investments from industrialized countries to developing countries due to various factors and crises, and this can be a problem for the recipient countries. Well, I would come back to start a second round. The response to this criticism by the various bodies. So we have said there is a new models of treaties, reduction on the FET standard, the fair and equitable treatment, which is more vague, it's more specified, like in CETA between the EU and Canada. But there are a lot of activities also concerning the dispute, the legitimacy, the accountability, as Gabrielle and Yas have especially said. What is your view on the various action in course? On the floor, there is ICSID proposed amendment to the rules of procedure, which is taking, I think, more time than expected by the Secretariat to streamline proceedings, time, cost, transparency. There is ICSID UNCTAD proposal on codes of conduct for arbitrators, disclosure, conflicts, double hatting, so-called. There is an issue of transparency or limiting third-party funding. Is that protecting the small investors who don't have money to do the cases, or is this provoking more cases than would be reasonable? And reducing tribunals' discretion. Let's have a round on this issue, maybe starting again by Yas and going on.
With pleasure, Giorgio, and I will be brief. There's two initiatives that I find truly welcome. The one is the draft code of conduct for adjudicators by ICSID and UNCTAD, simply because, again, that also addresses the perception issue with regard to arbitrators, and there's a number of questions that are tackled, the multiple roles, that it's important to have a view, again, to the extent that we're doing a bottom-up approach and really try to look at what the issue is and how the perception is expressed and how we can address that. And that goes hand in hand with the duty of diligence and disclosure. And these are topics that are addressed in the draft code of conduct. Disclosure is a very interesting one because we do have the IBA guidelines on conflict of interest, but different institutions have developed different approaches, and arbitrators themselves individually have developed practices. Some arbitrators being extremely cautious, others being not less cautious, but having just a different approach to how they disclose. So having a more uniform, harmonized way of looking at things in relation to these questions, I think, is very welcome. To the extent possible, I mean, if the perception concerns arbitrators, so the code of conduct does not address party conduct or expert conduct. We may see issues with experts in arbitrations for that matter, but leaving that aside, I think that it's an interesting initiative, and that hopefully will result in a code of conduct that can become direction for all of us. The other initiative that I find extremely important is third-party funding. I think that, again, that's very cultural. Some countries culturally have no issue with third-party funding, others do. In France, we're not used to third-party funding. I personally took a lot of time to even come to the notion of third-party funding. I think that to the extent that that can be tackled at the same time as looking at how states can be funded, that is an important factor, because I know that the UNCTAD work is looking at the advisory center and how, and UNCTAD also did that in the past, and how those institutions can help states. But I think that there's a broader issue of also financing states when they're defending, because by definition, third-party funding is also only for the claimants. That's how the mechanism works. And we've seen in very restricted number of cases where you have third-party funding for the public entity, but there has to be a counterclaim. Otherwise, you cannot get funding. So third-party funding, major issue for me, but at the same time, if we can in parallel look at the funding of states, I think that also would be very important. Thank you.
Thank you very much. What's the view of Gabrielle? You have an extensive experience in all sorts of commercial and investment cases. I will just come in shortly. My personal experience on transparency, for instance, everybody speaks, especially from the government side, of transparency, but then when it comes to allow the publication and disclosure of awards, and the governments are in the first line to say, no, this is state affairs, we don't agree. Please, Gabrielle, I see you're smiling. You surely have had also experience in these cases. Very frustrating for academics when they are called for as arbitrators. They would like to disclose their nice reasoning in the award, and then the governmental party or the losing party says, no, this is confidential. Please, Gabrielle. Non la posso sentire.
Sorry, I trusted that I would be unmuted. I try to be brief because I know that there's lots of questions we want to cover in a relatively short time. Let me just take transparency. Transparency has already been fixed to the extent it was a concern by the transparency rules of UNCTAD and the Mauritius Convention. The real difficulty is about implementing transparency. And I'm a strong proponent of transparency, although I realize that it makes management of cases more cumbersome. But each time I start an investment arbitration, I ask the parties whether they want to use the transparency rules. And I'm often disappointed. And I'm not disappointed by those who usually you would expect to oppose transparency, who are the businesses, the investors. I'm more disappointed by states. And so there's some kind of double discourse on transparency, an official discourse that this is good, and less official discourse that, yes, we're all in favor of transparency, but for this case, we would rather not have it. And I can understand that in part because it may be more difficult for a government to conduct an arbitration while there is the information is in the public and there is at the same time a public debate. There may be questions in parliaments. All this is difficult. But then I thought everybody was in favor of transparency, so maybe we should also deal with the unpleasant side of it and stick to the principle. In terms of the procedural reforms, there's many ongoing, both on ICSID and UNCTAD. It so happened that I would focus on the same ones that Yas already addressed, and for the very same reasons. The code of conduct. There's no shortage of rules of conduct for arbitrators. They're all over the place. There's many soft law texts. There's national law rules when you're in non-ICSID arbitration. There's jurisprudence, ICSID cases on disqualification, for instance. So there's a wealth of information of how arbitrators should behave. What's lacking is a uniform standard, and that is the main achievement, I would say, of the code of conduct. It is comprehensive in that sense. It is also useful. It's comprehensive, especially on disclosure. Maybe that will foster a more uniform practice of disclosure that currently is varied. And there's also a rule on double hatting. Now, what it exactly will be is still open and debated, but it would be good that we get to an understanding on this issue. I understand that most states are in favor of a ban. That is well understandable. It's probably, in principle, the right rule. It will backfire on the expansion of the pool and on the diversity of the pool, because younger people will have more difficulty joining the pool, because during a number of years they would accumulate different roles like counsel and arbitrator. And that may be, that is, I mean, the diversity of the pool to me is an issue as well, and we should be careful about it. Third-party funding needs to be regulated, but is not a bad thing in the sense that it is a tool for access to justice. And when we know the costs of standard investment arbitration for a claimant, $6 million US, and if you're lose and have to pay the other side's costs, that will be double that. There's many SMEs who cannot afford it, and I think in that sense it's a good thing, but it needs to be regulated, especially in terms of disclosure. And I stop here so that I don't take too much time.
Okay, thank you very much. Nicolás, where do you want to focus on this menu on the table? There is one menu which is a form of the substance and another rich menu, a form of procedure, but they appear to take a lot of time, especially the one on procedure.
Yeah, thanks, Giorgio. So actually, I would like to distinguish two different types of concerns here, and I think some of them, particularly the ones that Yas and Gabrielle just mentioned, fall within the preoccupations of practitioners, like, you know, and some state officials, and I think these concerns are essentially at the case-by-case level. So one important one definitely is third-party funding, which I think that has a key problem of third-party funding is that it promotes disputes that otherwise might have not been filed, because then what happens is that the claimant can, you know, shift the risk of the financial risk of the case, and then it might, you know, increase the number of disputes that otherwise, as I said, would not be filed. But I wanted to concentrate on a different type of concerns, because I think we have the concerns at the case-by-case level, like individual cases, but you also have systemic concerns that have been, put forward by some governments, but also by development economies who stress the importance of experimentalism in policy making, of civil society, and also by the local communities that are impacted by specific projects like extractive projects. And I think so that we have at one level the concerns that you mentioned, Giorgio, and I think these concerns have been identified by UNCTAD, and by the Untitled Group 3 and by ICSID, and refers to time, cost, predictability, and all these questions in a way are being discussed by Untitled Group 3 and the others. And I think Gabrielle and Jess already mentioned some of the initiatives on this side. But I think it's difficult. Then we have these broader concerns, and it's difficult to think about them through the current legal culture or imagination, if you want to, through this arbitration culture that dominates international investment law. These issues that we see from the Ancestral Group 3 are in the agenda. They remain in the agenda. There doesn't seem to appear to be a clear way in which the working group can deal with these problems, or is planning to address these broader concerns. The problems of the tension between the private and the public, investor rights on the one hand, and on the one hand, tension between the global north, the global and the north. There is also tension between the global, between the north and the south. All these concerns are very difficult to address within the current system. To illustrate what I mean here, let's take the case of the call for an ISDS moratorium on COVID-19 related disputes. So we might think this is a good idea, we might think this is a bad idea, but I think one of the interesting things is that there is no a clear international forum where states could consider this question and implement a decision. So there is a stark difference between the way we deal with trade and the structure of the WTO, the institutional structure of the WTO, and what we see in the investment model. So I think if FDI, so we all agree that foreign investment is key to sustainable development. It's difficult it's baffling to me how the investment, how we treat international investment so differently from trade. So within the trade structure, we have not just the dispute settlement understanding, but also other institutions, other diplomatic institutions where states can sit down, negotiate, and try to reach consensus. But we don't have that on the investment side. We don't have that where states can sit and negotiate questions like how we're going to deal with the COVID-19 crisis, or many of the other things that James was referring before. And this is where I find it difficult, How is it that we can, through these procedural reforms, get to an investment regime that is able to deal with the challenges of the tension between the global and the local, of the problems that local communities suffer when they're impacted by an investment? I find that there is here a mismatch that we cannot, we have identified what we cannot really address with the tools that the current investment regime provide us. And that's what I was saying. We kind of stuck with this culture, kind of stuck with this imagination, and it's difficult to think outside this box. So I leave it here. Thank you.
Thank you very much. Well, even at the WTO, the proposal to lift or suspend the IP regime in relation with COVID and other initiatives have been shown to be difficult to develop because, of course, you have different point of views between states and between stakeholders. Hélène, what's your thinking?
Thank you very much. I will avoid repeating what has already been said. In a nutshell, when we look at the list of improvements that you mentioned, of course, if the system, if ISDS is faster, cheaper, more transparent, and and there is no doubt about the legitimacy of the arbitrators, then of course the system will be better off. But once again, we may have on this both an external view and an internal view, like I proposed for the previous question. The move of the system, the example of the draft code of conduct is of course a good one. Everyone agrees, but at the same time, you can also consider it was vital for the system itself. And this is why we may have considered that this the code of conduct is somehow a low-hanging fruit, because there is a common interest in promoting the idea and the perception that the system is becoming more and more ethical. And so, or at least that ethics are guaranteed. So, but at the same time, from a more internal point of view, there are issues that we see coming, which would require that we are a bit clearer about the objective that we assign to the system as such. And we can see a procedural question rising. So third-party funding was mentioned. I wouldn't say that it's good or bad, but I don't have an as straightforward answer as Yas has, for example, because I think it's a bit more complicated than what she mentioned. And then behind third-party funding, you find other procedural issues like security for costs, which are increasing issues in arbitration, and these issues require answers, and these answers have to be thought with regard to the objective we assign to the system. And I'm not sure that this reflection is really developed. In this regard, I agree that the issue of the financing of the states is also an issue, but this is a reflection which also took place at the WTO, because there you have this question to see whether states do not become somehow the spokespersons of private interests, these private interests financing, in fact, the defense or so it's not that easy to answer all these questions, and I think we have also to take the systemic perspectives. And if I look also at the substantive dimension of the issue, whether improvement will come from new generation treaties, I dare not delving a lot into this, account taken of all what James said, and he knows far better than I do. But my feeling when I see the debate about the right to regulate, for example, these notions which are growing in the field at the substantive level, I wonder somehow if we do not see new clothes for old questions, because the right to regulate is a name to speak about state sovereignty. And so I'm not sure that these debates are that new. Maybe we put new words on them, and it's necessary in rhetorical terms to translate in common language this point of inflection that James was mentioning. But at the same time, I don't have a huge feeling of novelty with this debate. So I don't mean these are not improvements, but once again, I take a bit more agnostic stance in this regard. Thank you.
Thank you. So James may give us his reflection on this question that Hélène has put on the floor, but has not answered herself.
Well, thanks, Giorgio. I thought I still have a couple of important points I haven't made. One is about still the direction of the international investment, the investment policy making. This the developing country dichotomy. I would say if we review the past, we see that the regulation model for advanced countries is more kind of liberal in pre-entry and pre-establishment. Okay, pre-establishment more free, but regulation at the post-establishment level through competition policies and others. That is the developed countries model traditionally, and for developing countries, it was the opposite.
Well, thank you very much, Zhan, for this broad reflection. I would now ask you, well, an answer of a systemic change could be, of course, the proposal by the European Union to replace ISDS with multilateral court. And a first attempt has been made in some bilateral treaties with Canada, with Vietnam, to have a bilateral tribunal. Of course, the court brings more reflections, reactions. On one hand, it stabilizes and elevates the level of procedural protection while trying to answer to concern about legitimacy, accountability, type of adjudicators. But of course, there is a criticism of the private sector that says, well, there will be only state-appointed judges which will judge cases which under the system are mostly or exclusively brought by investors who claim that their investment protection has been infringed. Is this an answer part of the difficulties to enact this? But we have seen in the world that two systems may coexist. We have an international criminal court where major countries are not part, even the Tribunal of the Law of the Sea, but still these, let's say, plurilateral treaties in commercial terms could fly. What is your attitude towards this kind of proposal? And since I am speaking, I would like to invite the public to ask us questions. I see the public chat. I see nice greetings from faraway places like Kenya, Nairobi, and others. It's nice to know that we are followed all over the world. This is the advantage of these Zoom sessions. Maybe people who would not have been able to come in person to Milan. But if you have questions in substance, thank you to Gabrielle Marceau, who is saying hello to everyone from the WTO. And so if you have questions, please put them in the public chat and we'll try to answer. So my question on the idea of the court to replace or to complement the current arbitral system. We start again from Yas and we go on like this. Please.
Thank you, Giorgio. It all depends on why we're doing this. If the main purpose is to achieve consistency, first of all, I think that, as I mentioned earlier, the remarkable consistency of the case law when you look at the decentralization of the system cannot go unnoticed. Today, you have a number of issues, most favored nation clause, whether or not it applies to dispute resolution. That is definitely one way of inconsistency between tribunals. But if you look broadly, there's a good level of consistency, and whether that's a problem, you can take it from a systemic standpoint and say, yes, I want to see predictability, consistency, and then, but that you have that challenge. But if you see it from the party's perspective, I remember years ago, a member of the Procuración in Argentina said, I like the lack of consistency because instead of necessity, I can argue again and again and again, and maybe I will win differently. So the party's perspective can be different than when you look at it from a systemic perspective. So I'm just now talking about the systemic perspective. And from that perspective, I think that it can coexist for sure. Having an appeal in different treaties, you do not resolve the decentralization because you will have still an appeal in one treaty. It may or may not work. I think that you should not undermine or underestimate the tendency of the parties to re-argue all over again through appeal. So it will add costs and burden. So to what extent an appeal in itself will resolve the inconsistency, I think we may question that. I don't have the answer, but we've not seen it as a system again, but we may wonder. I think that a multilateral court will really be effective when we will have a multilateral instrument that will be underlying what the court will do, and that's where we will be able to reach consistency. It's a challenge, it's not undoable, but if we're looking at ways to address this, maybe we also want to look in the future into a multilateral instrument, because that's the way where the court will have a way of interpreting in a consistent, harmonious manner the different substantive protections. Otherwise, we will just have a coexistence. To me, again, looking as an observer at the system, I think that, you know, despite the decentralization, we still have a body of case law which is quite amazing if you look at just the issues themselves. Thank you, Giorgio.
Thank you very much. Gabrielle?
And the appeal, the court would remedy the lack. I speak of a multilateral court now, and of course I realize that there will be different systems or different regimes in place for a long time, but maybe there will at one point be one court that somehow is representative enough to set a number of standards. It would remedy the lack of inconsistency. It is true that for a fragmented system like the one we have now, the consistency is not bad, but there's still many issues where we have no predictability, no certainty of the law, and that triggers a lot of inefficiencies because cases are brought when they actually because you don't know what this tribunal will think, and you try just your chance. And the same thing is for arguments are run that actually, if you had a uniform outcome, you would know that they're doomed to failure and they would not be brought. So there's an efficiency problem there. The court would also, and Giorgio has alluded to this, solve the lack of legitimacy in the sense of having adjudicators who are have more legitimacy, accountability. It will probably solve the lack of diversity of the decision makers because you can set aspirational or maybe even kind of quota requirements in the instrument that sets up the court. So it has a number of advantages. Now, it also does create other problems. One other problem, the main one probably is the selection of the judges. And that is a challenge, how to make sure that they're independent, they're competent, and they're diverse. That their independence is somewhat different from the independence of arbitrators. Arbitrators' independence is more an individual issue. Here, it may be more a collective, a structural independence that is at issue, how to avoid that there is political interference into the court's work. And that is, of course, goes to the objection that a number of people raise, which is all the judges will be appointed by the states. That is probably true. That's the same thing for any court, by the way. But that can be, these problems can be resolved or at least significantly mitigated by a number of measures. And we have a lot of experience by now with international courts. We have models from which we should, or models in the sense that these are these set standards that can be followed, that have shown that they work. And we have also others from which we can draw lessons in what not to replicate. We should certainly have good criteria in the for a judge's selection in the instrument that sets up the court, an open, transparent process for selection with consultations, including consultations among a business community, open calls for applications, independent screening bodies, long-term non-renewable terms to avoid judges being influenced in their decision-making by the prospect of being renewed or not renewed. So all of this we have now a wealth of experience and studies on these issues, and it can be done probably in a successful manner. It will always coexist with other ISDS because
thank you, Gabrielle.
but I'm stopping here in any event.
You are cautiously optimistic of the advantages that the court might bring and reducing the inconveniences. Nicolás?
Thank you, Giorgio. So I think I'll agree with Jazz, with what she was saying, that actually I don't think inconsistency is a serious problem. Actually, despite the decentralized nature of the investment treaty regime of ISDS, you see a high level of consistency. So for instance, I mean, an issue that is quite controversial, which is legitimate expectations. You don't see many tribunals saying that legitimate expectations should not be protected. In fact, I can only count 3 dissents where arbitrators have said that they are not protected under the treaties. So you don't see arbitrators saying, actually, you know, the FET should be interpreted as in near and Mexico. You actually see in this some consistency. And I think what James is saying is interesting with regards to the use of new generation treaties in ISDS to file cases. I would be a little bit less optimistic than he is, at least when it comes to their interpretation. We have seen him in Bear Creek in Peru and in a recent case against Costa Rica that the interpretation of so-called exceptions, or let's say the state's right to regulate or sovereignty, as Hélène was saying, was not as some people have expected when it comes to the protection of the environment and on local communities. So I actually find that ISDS is quite consistent in this regard. So I think practitioners argue cases and arbitrators decide them against more or less the same legal culture, the same legal imagination. So I will get perhaps a little bit academic here, but I think there are no problems of communications, between practitioners and arbitrators. I think that the communication is going quite well. There's no fragmentation. Now, of course, I think the situation looks slightly different from the broader concerns I was talking earlier, the concerns of local communities, the concerns of development economies, who are, in favor of experimentalism when it comes to policy making. Here, I think that the problems are significant, because I don't think the question, I want to insist with this, I don't think the question is just investors' rights against the right to regulate or sovereignty in the old fashion, but rather that there are different levels of tension here. So it's not just the private and the public, but again, the North and the South, the different needs of different countries that are in different development stages, are also the tension between the global, the transnational, and the local, and more specific. So actually, at this level, I do think that there are problems of communication, that there is fragmentation going on. So there is a question, actually, a tension, because local communities cannot really, do not really talk the same language, and cannot, make their claims within the same mindset. And I think this is an important issue, and it leads to the question of whether a court can solve these problems or not. I mean, I think foreign investment is a very important topic from a policy and political point. So it really requires an appropriate institutional design to deal with all the challenges that we see. And I don't think that resolving the dispute, let's say dispute settlement, is enough to this. I think we do need something broader than this. I don't think the WTO could do its job very well if it was reduced again to the dispute settlement understanding. So foreign investment governments cannot be reduced to dispute settlement. I think That's the key question. So maybe I would think that a court could be part of the solution if it was part of a broader institutional organization where states and non-state actors can sit down and discuss issues of mutual concern, not just state sovereignty, but also the rights, the concerns of environmental activists, the concerns of local communities. And in a way, this institutional organization needs to be able not only to resolve disputes, but also to ensure that FDI will contribute to sustainable development. So this broader and more sophisticated institutional design, I think, is where we should be looking to, as opposed just to a system that is limited to resolving disputes, because no matter how important it is to resolve disputes, and of course it's very important that they're resolved through the rule of law, we need a system that is geared to sustainable development, that is geared to reaching the sustainable development goals, and not just to resolve discrete individual disputes. So the systemic issues cannot be left behind to be resolved by somebody else later on, because they must be resolved by us and today. So I'll leave it there. Thank you, Giorgio.
Thank you. I'm reminded that our time is finishing, so I'll give the floor to James, and then I have a few questions. I will try to merge them. I thank those who have put them, and there are a couple of issues that might be interesting and not covered by us. Please, Zhan, James.
Thanks, Giorgio. I didn't realize we have more time. So let me join the discussion on the procedure aspect. I think there's one issue that merits attention. That is the rule takers, not the rule makers. The rule takers are sometimes struggling with the consistency of dealing with ISDS and with dispute settlement mechanisms. For example, a country like Vietnam, it's a country that dealing with the three systems, meaning that Vietnam signed a treaty with EU, and then they have to deal with the investment court system, while they signed a treaty with US and others, and they have to deal with ISDS system, while they are part of ASEAN investment area, and they have still another system, which is the amicable kind of a solution without any ISDS or investment court. So there will be more and more countries which are the rule takers. How are they going to cope with this dispute settlement mechanisms in a different ways? So that is a challenging for developing countries. I would say that's something that needs to be dealt with, which hasn't been dealt with yet. So just pay attention to that. I wish to raise that. Now, I think there's an important question raised by Peter van der Bosch, and that's a forward-looking question too. And he said in the chat, what are the prospects for the multilateral investment agreements in the medium term? So he had a nuance of a medium term. I would say the use of the kind of cliche saying that the bridge is still too far. I would say not only short term, but medium term, given the current direction of global investment policymaking trends. And this, as I mentioned, the trends of deglobalization and the trend for more flexibility and policy space in order to pursue sustainable development goals and objectives. And because of these two trends, that it will be difficult to have kind of a multilateral agreement on investment. There could be some kind of, in the future, human rights sphere, climate change, environment, labor. In those areas, there are some kind of multilateral principles, agreements that touch upon the investment issues, but I wouldn't imagine a kind of a medium-term kind of multilateral investment agreement. I'm talking about comprehensive ones. The current efforts of investment facilitation at WTO, it is hopeful, but it is very limited because of the ambition. The level of ambition is low. I think it's commendable, but I'm more realistic. The joke I made on the side is that we're trying to make a wheel of the four wheels of a car, knowing that that investment regime consists of 5 to 6 major components: liberalization, promotion, facilitation, protection, disputes, and all these things. It's a systematic thing. Investment facilitation is a low-hanging fruit, but then the challenge is not only to conclude such a kind of investment facilitation agreement in the WTO. It's a question how it fits into the system of existing multi-layered, multifaceted, highly fragmented, highly atomized system that play a role on that. It's different from trade facilitation agreement because it is implanted into a system, WTO system, trading system. It adds on to the others and it fits well. But investment facilitation as a multilateral thing dangling there, the challenges in implementation and the effectiveness impact on the ground. But that's the only efforts I see. There may be some light at the tunnel, but that's a spare parts making.
Thank you. We have several questions just to conclude. I think many concern moving from a system that is focused on investors' protection in order to promote investment, to a system where democratic value, labor rights, human rights, sustainable development goals, as James just mentioned, would also be protected. And the second question is, what happens if these reform at UNCTAD or at UNCTAD are not attained? Will there be a frustration, a backlash against the legitimacy of this current system in view of the fact that it's difficult in all fora to agree on common principles in today's but also maybe more divided world? Who wants to make a reflection? I answer a question on that, but can this system of IIAs and investments go more into protecting other values? I think that new NAFTA has tried to do this. The most recent models of FTAs by the European Union incorporate more. Had a case of a panel, a dispute, not strict in arbitration between EU and Korea on labor rights, for instance. Who wants to say something on these issues? We have a couple of minutes more, maybe a few, since we started later. Gabrielle, one of these questions was addressed really to you, so I ask you with your rich experience.
Thank you. It seems to me that I was speaking of democratic value in respect of the person of the decision maker, but we can of course expand it to the substance of the rules that are being applied. It seems to me, and it has been already stressed by a number of speakers, that the new treaties have increased protection of values such as environmental interests, human rights, labor. Some have specific provisions on corporate social responsibility, and that, of course, is a clear evolution that we see in treaty drafting, and obviously ISDS will have, whatever it is, will have to apply these provisions. In addition, there's already, at least to some extent, cases that do take into account public policy purposes, health, public health, environmental protection, and the like. So it seems a clear trend, and I cannot see dispute resolution not taking this into account as we go forward.
Thank you. Maybe another panelist who wants to add the final word on this, and then we'll close. We have been a quarter of an hour more, and we'll have further and then interesting parallel panels starting in the afternoon. Yes.
If I may, Giorgio,
yes, please.
I think this is what I call the sustainability imperatives, mainstreaming into the investment laws and regulations. Certainly, it will have some impact on the investor-state disputes. I would say at this stage, if you look at the new treaties, it's more a kind of carve-outs or safeguarding instead of very proactively saying that my treaty is promoting human rights, labor issues, standards, or that environmental standards. It's more of saying that still protecting, promoting, facilitating investment, and in doing so, just to carve out if there's policy changes. So it's more towards the direction of policy space and flexibility, which may have some implications as early on that the panelists and I think Gabrielle also emphasized on this stability, predictability, and transparency, while the policy space flexibility is going towards the other direction, so to speak. Certainly in the future, there could be for the new generation of cases, cases for new generation of investment treaties, these issues could be on the table.
Okay, thank you very much. I think we will go soon off stage. I want to thank you, all of you. We know most of us personally, and it's nice to have this possibility from our offices or homes or universities being able to talk together. And I hope the public will consider that we gave a good start to these sessions of SIEL, and please keep in touch. There are many other interesting panels, and thank you to the public that has followed us. I don't know how many, but we will know that. Our technician will tell us. So have a good day, all of you, and thank you very much again on behalf of SIEL. Ciao. And let's hope that Italy will win the final for the European football after the success of last night. Sorry for for Hélène, who is half Spanish, I understand, but that's how it goes. Thank you.
Thank you, Giorgio.
Thank you.
Thank you for moderating the session.
Bye-bye.
Thank you. Bye-bye.
Bye-bye.
Bye-bye.